My name is Keely. Welcome to US Visa and Law Guide. Let us get into it. Before we dive into the rule itself, I want to give you a quick reminder. I am your guide, not your lawyer. What I share today is to help you understand the landscape clearly, honestly, without the noise. For your specific situation, especially if your CDL or immigration status is involved, please connect with a licensed immigration attorney or a transportation compliance expert. Now, let us talk about the rule. Picture this. It is a Friday morning in February 2026. Truck drivers across the country wake up, check their phones, and see a headline that stops them cold. The Federal Motor Carrier Safety Administration, the FMCSA, the federal agency that oversees commercial trucking, has just released what they called an interim final rule. The title alone should give you a hint at the urgency they were projecting. Restoring integrity to the issuance of non-domiciled commercial driver's licenses. Now, what does that mean in plain English? Let me back up for a moment. Because to understand the new rule, you first need to understand the old system. And the old system starts with a term that sounds more complicated than it is, non-domiciled CDL. A regular CDL, a commercial driver's license, is issued by the state where you live. Simple. If you live in Texas, Texas issues your CDL. If you live in Florida, Florida gives you yours. But what about someone who is legally in the United States, legally authorized to work, but does not have a permanent address in a single state? Maybe they are a seasonal worker. Maybe they came from another country on a work visa and are living in multiple places. Maybe they are a refugee who is still in the process of establishing permanent residency. For those drivers, states could issue what is called a non-domiciled CDL. Same license, same testing, same medical requirements, same background checks, just issued under a slightly different category. And up until September 2025, you could qualify for a non-domiciled CDL if you had one key document, a valid employment authorization document, commonly called an EAD or a work permit. If the government said you were authorized to work in the United States, that was enough. That was the standard. And under that standard, hundreds of thousands of drivers kept America's supply chain moving. daca recipients, TPS holders, asylum seekers, refugees, people who had been through the legal process, gotten their papers, completed their training, passed their tests, and built entire careers behind the wheel of a commercial vehicle. And then, in September 2025, the government changed the rules. Here is what the new rule actually says, and I want to be very precise here because this is where the headlines get messy. The FMCSA announced that a work permit, an EAD, is no longer enough to qualify for a non-domiciled CDL. Going forward, you must hold one of only three specific visa types: H-2A, that is a temporary agricultural worker visa; H-2B, that is a temporary non-agricultural worker visa; E2, that is a treaty investor visa. That is it. Three visa types out of the dozens of lawful immigration statuses that exist in the United States. What does that mean for everyone else? It means that if you hold daca, you are no longer eligible. If you are an asylum seeker or an asylee, no longer eligible. If you have temporary protected status, TPS, no longer eligible. If you came through the refugee program, no longer eligible. If you are on humanitarian parole, not eligible. And critically, an employment authorization document alone, no longer enough. The FMCSA estimates that this rule will eventually force approximately 194,000 drivers out of the freight market. Let that number settle for a moment. 194,000 people. That is 97% of all current non-domiciled CDL holders, people who trained for months, people who invested thousands of dollars, people who built entire businesses. And when does this happen? Not all at once. The rule does not immediately cancel anyone's existing CDL. Here is the critical detail. If you already have a valid non-domiciled CDL and valid work authorization, you can continue to drive until your current license expires. The rule applies at the point of renewal. When your CDL comes up for renewal, that is when the new standards kick in. And if you no longer meet the new eligibility criteria, you cannot renew. This is a rolling wave. Over the next several years, as licenses expire one by one, drivers who do not hold H2A, H2B, or E2 status will be phased out. The FMCSA originally estimated this would take about 2 years. After auditing state records, they now believe most of these CDLs were issued with validity periods of up to 5 years, so the impact may stretch even longer. But gradual does not mean painless, and it certainly does not mean unchallenged. Now, I want to tell you about what happened next, because this is the part of the story that gives many people hope, and it is also the part that most news coverage barely touched. Jorge Rivera Lujan, the DACA truck driver I told you about at the beginning, he did not just accept this ruling, he sued. Together with other affected drivers, including an asylum seeker named Alexei Semenovsky, a Ukrainian driver who had been working legally in the United States, and the support of major unions, including the American Federation of Teachers and the American Federation of State, County, and Municipal Employees, Jorge filed a federal lawsuit against the FMCSA. Their argument: the government broke its own rules. The law requires that before a final rule takes effect, the government must go through a notice and comment period. They have to publish the proposed rule, let the public weigh in, and genuinely consider the feedback. Instead, the FMCSA issued this as an interim final rule, meaning it took effect immediately without that public comment process. The courts took that argument seriously. In November 2025, the United States Court of Appeals for the D.C. Circuit issued an administrative stay, a pause, on the rule. States could continue issuing non-domiciled CDLs under the old standards while the court reviewed the challenge. The FMCSA responded by going back and completing the formal rulemaking process, taking in over 8,000 public comments, and then published a final rule on February 13th, 2026. This final rule is essentially the same as the interim rule, the same visa restrictions, the same EAD exclusions with minor clarifications, and it is scheduled to take effect on March 16th, 2026, but on February 12th, 2026, one day before the final rule was even published, the same plaintiffs filed a new lawsuit in the D.C. Circuit challenging the final rule. That case is now pending. Enforcement of the rule could be stayed again. The legal battle is not over. What does that mean for you? It means this: the rule is real, it is on the books, and its effective date is March 16th, 2026, unless a court steps in again. Watch this space, check official FMCSA communications, and if you are affected, talk to an attorney. Now, I want to take a step back because underneath all the legal language and all the policy debate, there are real people living real lives in the middle of all this, and I think those stories deserve to be told. Imagine a man like, let us call him Carlos. He came to the United States from El Salvador years ago under temporary protected status. He got his work permit. He went to a federally approved truck driving school. He spent months learning how to safely operate a 40-ton vehicle. He passed every test. He got his CDL, and then he built a life. He bought a modest home. He has 2 kids in school. He drives refrigerated freight, the kind that carries your produce from California to Ohio, that carries medicine from port to pharmacy. When this rule was announced, Carlos did not lose his CDL immediately. He still has it. He can still drive, but his CDL expires in 2 years. And when it does, under the current rule, he cannot renew it. Not because he is a bad driver, not because he is a safety risk, but because the wrong 3 letters appear on his immigration paperwork. Or consider a woman, a Ukrainian driver. She fled a war. She went through official refugee vetting, which is, by the way, one of the most rigorous vetting processes in the entire U.S. immigration system. She got her work authorization. She trained for her CDL. She has been driving safely for 2.5 years, paying taxes, supporting her children. When the rule was first announced, she wrote a comment to the fmcsa. She said, "I work hard to keep America moving. I speak good English. I am a safe driver. But now, with this new rule, I lose the opportunity to work." More than 80% of the 8,000 public comments submitted to the fmcsa oppose this rule. Drivers, unions, advocacy groups, state attorneys general, trucking industry stakeholders, all saying the same thing in different ways. This does not make sense. Now, here is the question that is on a lot of people's minds. Is this really about safety, or is it about something else? The FMCSA says it is about safety. They point to a loophole, the fact that states could not access foreign driving records for non-domiciled CDL holders. They say this means some drivers may have had accidents or violations in their home countries that American licensing agencies had no way of knowing about. They cite 17 fatal crashes in 2025 involving non-domiciled CDL holders as evidence. Critics, and there are many, push back hard on this. The Niskanen Center, a nonpartisan think tank, published an analysis pointing out that the FMCSA itself stated there is no evidence of a relationship between the country of domicile on a CDL and safety outcomes. The rule applies to all non-domiciled drivers, regardless of safety record. A daca recipient who has driven safely for 11 years is treated identically to a brand new applicant with no history. That, critics say, is not a safety policy. That is an immigration policy wearing safety clothing. The Sikh Coalition filed a class action lawsuit. The AFL-CIO filed a brief. The Asian Law Caucus published a detailed guide for affected drivers in California, where an estimated 20,000 drivers were flagged for potential license cancellations. What we have here, to be honest with you, is a genuine ongoing dispute about what the rule is really for. I am not going to tell you what to think about that. I am going to give you the facts, and I am going to trust you to form your own view. What I will say is this: the legal fight is real, it is active, and it is not finished. The courts are involved, major organizations are involved. This is not a closed chapter. So, what does all of this mean for you? Let me break it down as clearly as I possibly can, depending on where you stand. If you are a U.S. citizen or a lawful permanent resident, a green card holder, this rule does not affect you. U.S. citizens and green card holders are not in the non-domiciled CDL category. They get regular CDLs from their state of domicile. Nothing about this rule changes that. You can rest easy because your commercial driving credentials are completely unaffected by this policy. If you hold an H-2A, H-2B, or E-2 visa, you are the group the rule was designed to include. Under the new standards, you can obtain a non-domiciled CDL. However, there are new requirements. You must appear in person at the licensing agency. Your CDL validity will be tied to your visa expiration date, meaning your license will not last longer than your authorized stay, and your immigration status will be verified through a federal database called SAVE, the Systematic Alien Verification for Entitlement System. Plan ahead. Keep your visa document. Number 2, this rule does not immediately revoke any existing CDL. Drivers with current valid non-domiciled CDLs and valid work authorization can continue to drive until their current license expires. The impact is felt at renewal time. Number 3, affected groups include DACA recipients, TPS holders, asylum seekers, asylees, refugees, humanitarian parolees, and other EAD holders. They will not be eligible to renew non-domiciled CDLs under the current rule. Number 4, a new lawsuit was filed in the D.C. Circuit on February 12, 2026, challenging the final rule. If the court issues a stay, enforcement could be paused again. Watch for court developments closely. Number 5, U.S. citizens and green card holders are completely unaffected. Their CDLs are standard state-issued licenses. This rule does not touch them. Number 6, if your CDL is expiring and you are in an affected immigration category, act now. Do not wait. Consult a licensed immigration attorney. Explore whether your visa category can be changed. Know your options before the clock runs out. Number 7, the legal fight is not over. Courts are reviewing. Organizations are fighting. Policy can change. Stay informed through official FMCSA communications at fmcsa.gov and through organizations like the Asian Law Caucus, the Sikh Coalition, and Public Citizen, which are actively tracking this issue. I want to close with the same place I started, with Jorge. As of right now, Jorge Rivera Lujan can still drive. His lawsuit helped pause the original rule. The legal process he helped set in motion forced the government to slow down, take public comments, and justify its reasoning. He did not just accept a policy he believed was unjust. He used the tools the system provides, and those tools worked. Not perfectly, not permanently, but they worked. That is what I want you to remember. The system has tools. Courts exist for a reason. Public comment periods exist for a reason. Organizations that advocate for drivers exist for a reason. And people like you, people who take the time to stay informed, are part of why those tools get used. Know your expiration dates, know your visa category, know your rights, talk to an attorney, and check back here because this story is not finished. If this helped you understand something you were confused about or if it gave you a little bit of peace in the middle of a lot of noise, let me know in the comments. I read every single one. I want to hear from you. What are your questions? What do you want me to cover next? What is keeping you up at night? You showed up today. That matters. Stay informed, stay calm, stay ready, and I will see you in the next update.